Welcome everyone to this webinar hosted by the Africa IP SME Helpdesk. Before we start, I would just like to flag a couple of housekeeping rules to make sure that presentations and all the participants can listen smoothly. This webinar is recorded. And therefore, we will make a training material afterwards, a training module that will be available on our website. So we will not give you the possibility to speak during the presentation. If you would like to interact or ask any question to the speaker and presenter, you can do it either by writing a question in the chat or by raising your hands, and our technicians will give you the possibility to speak up. So thank you very much again. It was a very short introduction. We will now get into the subject of the webinar. As mentioned, this is a webinar organized by the Africa IP SME Helpdesk. I am the project manager of this project. I'm Andrea Iori, and I work at the European Union Intellectual Property Office, an European Union agency based in Spain. And we've been tasked by the European Commission to promote this project called Africa IP SME Helpdesk, that is a support service for small and medium companies, mainly from the European Union, who are willing to invest or are already based in Africa and would like to protect and make use of their intellectual property assets. In order to do so, our project provides 3 services that are completely free of charge. First of all, we have a helpline, meaning that all companies that are interested in our services can contact us and email us. I will share in the chat later on the contacts to reach out to us. And you can ask questions on intellectual property in Africa, and we will provide an answer within 3 working days. As said, everything is for free. Then the second service that we provide, we have a website, and I will also post the information on the chat about this a bit later on, where you can find many learning materials and training modules on IP and Africa. So all this information, as said, is completely free, and all users are more than welcome to make use of it and to download all this information. And third service that we provide is the awareness raising and training support, meaning that we would like to interact to as many small and medium companies as possible, because it's our main objective is to get in touch with them and to provide them with information on IP. And in order to do so, we organize many training sessions like the one we are having today, both online, like webinars, but also on site. And we do also attend many matchmaking events and trade fairs where we directly get in contact with companies and where we will share with them all the services that we do. And we provide first-line IP advice, again, free of charge. So these are the 3 main services that we offer. And said that, I will now describe a little bit, introduce the webinar that we are hosting today. Today we are focusing on Nigeria. Our project covers all Africa, but today we decided to focus on this big and important country for Africa, and we will be discussing about intellectual property strategies for enhancing your business success in the Nigerian landscape. In order to do so, we will address several tips to entrepreneurs, to business owners, to SMEs in general, and we will cover 4 topics. So first of all, we will have a look at the Nigerian IP law landscape. We will then look into IP searches and the registration process. And then, of course, we will have a look on how these laws can be enforced, what are the litigation procedures, and also the alternative dispute resolution that are offered in Nigeria. And we will conclude with IP due diligence. That is an extremely important point for our successful commercialization strategy. And we will also present a few case studies to you in order to have an idea of how companies operate on IP in Nigeria. Who will do that? It will be our IP expert, Tolu Olaloye. We already collaborated with her in previous occasions, and her contribution was excellent. So we asked her to support us again with this webinar. Tolu is a partner at Jackson Etienne Edu, an African law firm headquartered in Lagos in Nigeria, and she currently manages several IP portfolios of corporations, SMEs, non-profit organizations, involving, for example, commercialization of IP assets, franchising, licensing, and so on. So she will be happy to answer to all your questions during this hour that we have at your disposal. And I will stop now and give the floor directly to Tolu, who is kindly invited to share the presentation and to start with the webinar itself. Thank you very much.
Good morning, everyone, and thank you for joining this webinar. I'm going to be taking us on the intellectual property strategies for business success in Nigeria. So if you're an SME or startup company listening to us this morning, it would be great to know what are the potential and benefits of IP strategies in Nigeria, understand the IP landscape in terms of protection, enforcement, and also what is the benefit of the IP due diligence to your company, and what strategies can you deploy in order to make use of the IP for the growth of your business. So without wasting too much of our time, I'm just going to go straight to the presentation for today. Thank you very much. So today we're going to be discussing about intellectual property strategies for business success in Nigeria. And these are going to be our outline for today. So I'm going to be looking at the potential and benefit of IP strategies in Nigeria. We'll consider the IP consideration for the business practice in the Nigeria, the main challenges in the Nigerian context, the main challenges of IP practices in Nigeria, and practical tips to overcome common issues, sustainable IP strategies for businesses, and then the case study from EU-based firms in Nigeria showcasing how they've been able to use intellectual property and the lessons learned from them. Okay, so we're going to be talking about the potential and benefits of IP strategies in Nigeria. When you look at the economy or most situation in terms of industry, having a robust intellectual property strategy is not just basically a smart move for businesses, but it is essential for companies in which for them to have rich IP portfolios, especially in Nigeria. So why is it basically essential to have a rich intellectual property strategies? Number one is that it helps to quantify and maximize a company's IP value. What do I mean by this? So if you have an IP strategy in place, it's a systematic framework to identify, track, quantify the worth of your company's IP assets. And this IP asset would basically include patents, trademarks, copyright, trade secrets, and it helps to prioritize the management and efforts the company use in terms of their valuable assets, ensuring that resources are allocated effectively. The second benefit is it helps to navigate the Nigerian market with confidence. It helps to navigate the Nigerian market with confidence. And if you have a robust IP strategy, basically it will equip your business to make an informed decisions on commercializing your IP rights within the nuances of Nigerian market. It's a big country in Africa, but of course, you need to understand how this market operates. And so when you have a robust IP strategy, it will help you to have that confidence to be able to navigate the market. And this basically goes beyond just selling your products, but it enables performance evaluation, accountability, continuous improvement, and optimal resource allocation. Another benefit is that there will be a continuously evolve and optimize. So when you have a comprehensive IP strategy, it creates an avenue to regularly review your company's IP management procedures, allows you to track the effectiveness and identify the areas for improvement over time. So what this actually does for you is that there will be a continuous situations where you'll be able to understand which of the IP you're using, which one is not important to you again, and then you can make some comprehensive decision as a result of that. And then one of the last benefit I will talk about this morning is it helps to find the counterfeit ties. Counterfeiting is actually a big issue or challenge in Nigeria as of today. But when you have a robust IP strategy, which is very crucial for implementing effective brand protection regime. So helping to safeguard a company's brand, reputation, market share, and consumer trust. That's what the IP would have done for you. So all the critical success in the Nigerian market, you would have used your IP, which you've already protected, to be able to fight this counterfeit tides. In conclusion, developing a tailored IP strategy is not just a box to tick. No, it's a powerful tool for any business to leverage its intellectual assets for competitive advantage and sustainable growth in Nigeria. So these are basically the benefits of having an IP strategist in Nigeria, which I have discussed that. One, it will help you to quantify your company's asset. It will help you navigate the market with confidence, and there will be a continuous optimization and involvement, and then it will also help you to fight the counterfeit. Now, let's go into the IP considerations. So let's go into the IP. I'm going to be discussing about the IP consideration for the business practices in the Nigeria context. And looking at this place, we're going to be looking at the Nigerian IP law landscape. And basically, Nigeria currently recognizes 4 broad forms of intellectual property rights, which is copyright, trademarks, patent, industrial designs. But in Nigeria, copyright, patent, designs, trademarks, and trade secrets are protectable as intellectual property. Under this subheading, we will consider the key legislations on intellectual property in Nigeria. Why? Because we are trying to understand the IP law landscape in Nigeria. The current legislation on IP in Nigeria today, we have the Copyright Act, which is the extant law on copyrights. It provides the legal framework for the protection of literary, artistic, musical, and other creative works. The bill widens protection to include digital content, among others, which were not covered in the existing law. And then the senator that actually helped to bring this law into place, the Senator Abiru, that actually argued that there was a need to have enact stronger law that would protect investment of copyright owners, stressing that there will be a need to protect the investment of copyright owners, stressing that copyright, if you look at the copyright of the 1988 as amended, it has been obsolete. So in addressing emerging and contemporary issues in the Nigerian copyright industry, the bill seeks to strengthen the copyright regime in order to enhance competitiveness of its creative industry. So if you look at the digital space and knowledge-based, because we are going into a system where we are having a knowledge-based global economy, and it would be good for us to have a law that can actually fulfill or be able to provide enough evidence for copyright. And it also helps to effectively protect the rights of authors to ensure just rewards and recognition for their intellectual efforts, while also providing appropriate recognition, limitation, and exception to guarantee access to creative works and encourage interchange and advance public welfare, among other benefits. The second law that we have in place in Nigeria, apart from the Copyright Act, is the Trademarks Act of 1967. And this act is the governing status on trademarks in Nigeria, and it protects distinctive marks like signs, logos, symbols, the name of your company, and it also distinguished goods and services. We also have the Patents, the Patents and Designs Act of 1970. This is the principal law on patents and designs in Nigeria, and it basically provides a legal framework for the protection of inventions and industrial designs. We also have some other applicable laws in Nigeria, which includes the Merchandise Marks Act, the Federal High Court Civil Procedure Rules, and then the Cyber Crimes Prohibition Prevention Act of 2015. It's interesting to know that there are actually some notable provisions and amendments that has actually occurred in the IP space. Earlier in 2023, the former President Muhammadu Buhari actually signed the Business Facilitation Miscellaneous Bill, now called the Business Facilitation Act. and into law. So the BFA seeks to promote the ease of doing business in Nigeria. And some of the notable amendments in the Act that borders on IP, it will be necessary to also discuss that this morning. One of them is that there will be an amendment of the Patent and Designs Act under the Business Facilitation Act. The BFA also introduced an amendment to first schedule of the Patents and Designs Act to expressly grant the Minister of Trade, Industry and Investment the power to actually prescribe procedure for the application, the grants, the use, and withdrawal of compulsory licenses by regulation. This was not there before, but the Business Facilitation Act has now given the minister the power to be able to grant these compulsory licenses by regulation. The Business Facilitation Act for trademarks also introduces an amendment to Section 67 of the Trademarks Act. Now, I'm pleased to let you know that if you come into Nigeria to protect your intellectual property, you have the opportunity, or if you are into services, because I know that there's some people listening to me this morning that they are basically into service, they are service providers. But it's interesting to know that in Nigeria today, you can actually also protect not only your goods, but also your services. And the Business Facilitation Act has given us that opportunity. This implies that specifically according to the use of trademarks to protect not just tangible goods, but services. Now, it's interesting to know that IP, but there are also some proposed legislation in the works for IP, which is to further strengthen the IP protection and landscape in Nigeria. So the interesting thing about Nigeria as of today is that ultimately we have things in the process that is helping us to look forward to having a robust environment for the protection of your intellectual property rights. There's some of this proposed legislation in the works which could further strengthen the IP protection landscape, such as we have the Plant Variety Protection Bill. We also have the Geographical Indication Bill also in the works, and the Nigerian Creative Industry Development Bill of 2023. It's interesting to know that we cannot be talking about the IP law landscape without also mentioning the fact that Nigeria has signed some treaties and also members of different conventions and treaties. Nigeria is a signatory to many IP treaties. However, such treaties need to be domesticated in law. So in Nigeria, and when I mean domesticated, it has to be in the act of the National Assembly before it can have the force of law in Nigeria. So there are some of the list of conventions that Nigeria has signed signatory to, but however, because they've not been domesticated into our law, there is always that issues as to how this law we can be able to enact them. One of those, I will just talk briefly about the treaties that we've signed. Nigeria is a signatory to WIPO Performance and Phonographies Treaty, WIPO Copyright Treaty, WIPO Convention, Rome Convention, Patent Law Treaty, Patent Corporation Treaty, Marrakesh VIP Treaty, Paris Convention, Benin Convention for Copyright, Benji Treaty on Audiovisual Performances, and Agreement on African Continental Free Trade Area, which is the recent one. Now, we understand what are the benefits of IP strategies. I've also been able to discuss the IP law landscape, the different laws in place, the acts and the regulations in place. I've also discussed the different conventions and treaties in which Nigeria has been a signatory to. Now we are going to be looking at IP searches and registration process in Nigeria. And the reason we're checking this is to basically help us to fully understand the consideration for businesses in Nigeria. If you're coming to Nigeria to start a business, these are the things that you have to put into consideration in terms of the protection of your IP rights. Now, I'm going to be going into the IP searches and registration process in Nigeria. It's interesting to know that IP searches are an integral part of intellectual property protection in Nigeria. It's an important preliminary stage. So if you're coming into the country, you want to bring your goods or your services, it's always very important to conduct those searches. And the searches, we usually call them availability searches or clearance searches. They're very crucial in determining if a company's proposed IP is available for registration in order to avoid infringements. Infringement is that maybe there's an existing trademarks or existing patent already in place, and you do not want to have a future infringement action against your brand. So it's very important that you check the availability or what we call the clearance searches. It also helps to save the time and costs that would have been expended on an IP, which will be flagged by the IP office in the cost of registration, especially in the case of trademarks for patents examination as to formality, not substance. So IP searches are usually conducted manually at the Nigerian Trademark Registry for patents and designs as well. And it's always as a fee. And the result by the office are based on availability on their records and at the time the searches is conducted. In terms of registration process, it's interesting to know that in Africa, we have basically two regional filing system, but Nigeria is not part of OAPI or ARIPO, which are not discussing that today. We are focusing on Nigeria. So in Nigeria, we have a separate filing system, and we are not a member of OAPI and ARIPO. And in the registration process through the national route, which is the Nigerian Trademarks, Patents and Design Registry, and it is processed manually or online. So we have the manual filings and we also have the online filings. And it's interesting to also know that when you're conducting your searches, the searches will check the clearance search, which is for availability searches, the status search. Probably you have a mark that you are not sure of, you want to acquire that brand and you want to know the status of that brand. And then we can also do proprietary search as well. So the general information and searches for IP searches and registration process in Nigeria, there are basically some general requirements when you are conducting your searches. So for trademark registrations, you need the name, the nationality, the address of the applicants, the name of the trademark or device mark. You also need the class. So we have classes 1 to 45, and it's interesting to know that in Nigeria, we actually use the NIST classification, which goes for the goods and services. Then the specification of goods in that class, a duly signed power of attorney or authorization of agent as well. Looking at the trademark registration process, in terms of the registration procedure, how the procedure works, so when you file your trademarks, you're going to have a filing called an acknowledgement notice, after which there's an examination, which is both relative and absolute on absolute grounds. And then after that, an acceptance is issued. After an acceptance is issued, the mark is published in the journal, so we call it advertisement publication, and then it gives the public the opportunity to know if that mark is similar or identical to any of their brands, and then they also have the opportunity to oppose it, which we call the opposition procedure, and that is also going to go for 2 months. If there's no opposition against the mark, you are then free to proceed to pay your selling fee or registration fees, after which the registrar would issue a certificate, and then you have your trademark registration certificate. So this is the procedure for trademark registration. Now we're going to be looking at the procedure for patent registration. For patent, the documentary required for patent, if you want to protect your inventions, is that you have to have a simple power of attorney or authorization of agents, a clean and clear copy of the specification claims, abstracts or drawings, including amendment if any necessary, a copy of the published PCT pamphlet comprising the complete specification, copy of international publication, international preliminary report on patentability, and international search report or written opinion. Then the text of the PCT specification claims filed should include any amendments affected by the annexes to the international preliminary examination report. And in terms of the registration procedure, so these are basically the requirement for patent registration in Nigeria. And the registration procedure is simple. You just have, so once you file your patent, you get your acknowledgement, there will be an examination. However, in Nigeria, it's interesting to let you know that the examination procedure is as to formality, it's not as to substance. So the patent application is examined to ensure its conformity with the documentary requirements stipulated by the Patents and Designs Act, after which an acceptance is issued, and then you get your letters patent certificate. So you have your patent certificate. Now I'm going to be looking at the registration procedure for designs. So for designs, the documentary requirement is that you have to have an application in the requisite form stating the article to which the design is to be applied, the statement of the novelty of the design, the specimen, photographic or graphical representations of the design, a power of attorney if application is being made by an agent, and an indication of the kind of products or class. And sometimes they also request like a photographic picture of of the design, like in terms of format. And then the foreign priority applications, which is going to be like a written declaration showing the dates, the number, country, and the name of the person who made the earlier application. The registration procedure for design basically is also simple. You have your filing, then you get your issuance of acknowledgement notice, examination in terms of the acceptance notice, registration upon the acceptance of the application and design. And upon the registration, a duplicate of the design certificate will be included in the Register of Industrial Design. So these are basically the different documentary requirements. If you want to protect your trademarks, remember that if you are protecting your trademark, you are protecting your name, your designs, your logo of the company. If it's the patent, you are protecting the invention, and invention which has industrial applicability. It's very important to know that when you're thinking of protecting your patent, it must be capable of having industrial applicability and it must be novel. And then for the design, it has to be an ornamental design, which is also novel as well. So these are the documentary requirement that is required, and these are the registration procedure for the three. Now, you might be asking, what about the copyright? It's interesting to know that for copyrights, we have automatic protection for copyrights in Nigeria. However, there is also the depository registration procedure, which is also done at the Copyright Commission. Now, I'm going to be going into the enforcement. I'm going to be going into the enforcement, litigation, and alternative dispute resolution. Recall that we are discussing here what are the different IP considerations for business strategies in Nigeria, and we've looked at the landscape. Now we are looking at different terrain in terms of your protection, and now we're going to be talking about the enforcement. So after you've protected your IP in terms of trademarks, copyright, and designs, now, how do you enforce those IP? How can you enforce it? Protecting intellectual property in Nigeria demands a nuanced understanding of the legal landscape and available enforcement strategies. And it's interesting to know that that is what we're discussing here today. The enforcement of intellectual property rights in Nigeria involves various judicial and administrative mechanisms. The laws governing or regulating the rights and protections in Nigeria are codified in various treaties, including extant IP laws, which I have discussed earlier, the extant IP laws in terms of the Trademarks Act, the Copyright Act, the Patent and Designs Act. Now, if you want to institute an action, the first court of instance is the Federal High Court, which is entrenched in the Constitution and reinforced by individual IP laws. And you can always seek your legal remedies, initiative prosecution, usually at the Federal High Court in the first instance, the Court of Appeal, and ultimately the Supreme Court, which exercise appellate jurisdiction on matters emanating from the Federal High Court. What do we mean by infringement? It's important to understand this. Infringement occurs when copyrightable works are used without authorization for commercial or non-commercial purposes. Then for patent, exploiting such assets without permission constitutes an infringement. Using identical or confusingly similar marks for the same or similar goods amounts to infringement. And I've also discussed which court has jurisdiction in Nigeria for you to be able to institute an infringement action. The court is the Federal High Court. And when you are looking at going into the courts, the average lifespan of cases in court usually lasts between 1 to 5 years outside of appeals. In terms of enforcement, there are several enforcement mechanisms and intellectual property rights holder can employ in enforcing intellectual property. Rights. The mechanisms include alternative dispute resolution, criminal complaints, civil action via the courts. So for you to be able to enforce your IP rights, there are basically different mechanisms that can be used. We have the ADR, which is the alternative dispute resolution. We have the criminal complaints, and we also have the civil action via the courts. In terms of the alternative dispute resolution, ADR options like mediation, arbitration offer faster and more cost-effective means of resolving IP disputes compared to litigation. And what we have seen over the years is that parties can agree to binding ADR processes, streamlining conflict resolution, and potentially preserving business relationships. While there is no express legislation on the arbitrability of IP disputes in Nigeria, there are scenarios which would allow arbitration mechanism to deploy in IP disputes. Contractual ADR provisions are common in franchising, licensing, or sponsorship agreements. Such an agreement would typically provide for dispute arising out of the contract. The court can also direct that parties resolve IP litigation through some form of ADR mechanism. Sometimes can be settlements, and report the outcome to the court. And that's why most of the IP litigation cases, you will see that it ends up being like settled out of court. And this has actually been confided in Section 17 of the Federal High Courts, which provide that in any proceedings in the courts, the court may promote reconciliation among the parties thereto and encourage facilitate the amicable settlement thereof. So with the above provision, the power to facilitate amicable resolution of dispute is provided by the Federal High Court, and similarly, Section 24 of the High Court of Lagos State 2003 also provides that the court may promote reconciliation. The reason why I'm explaining this is that it's just to be able to expatiate more on the ADR dispute process, which can also be used as a means of enforcing your IP in Nigeria. We also have the WIPO Center, which collaborates with the Trademarks and Patents and Design Registry in the promotion of the use of ADR options for intellectual property disputes in Nigeria. Similarly, a framework for collaboration between the Nigerian Copyright Commission and the World Intellectual Property Organization, WIPO, was established upon the signing of a Memorandum of Understanding in December 2020. So what we have in place in Nigeria today is that parties can refer most contractual and non-contractual commercial disputes to WIPO ADR procedures, and the Nigerian Copyright Commission and the WIPO Center, they jointly offer mediation services to copyright owners. And we have IP experts that are also members of the ADR community, and they also serve on this board. And other interested parties for a quick and cost-effective resolution of disputes. So it basically reduces administration. So you have like the amount is very free and includes 4 hours of preparation of mediation, additional hours, and all that. That is with respect to ADR as a means of enforcement. Now we also have what we call the criminal complaints. Reporting the blatant infringement to law enforcement agencies like the Nigerian Copyright Commission or the Nigerian Trademark Registry or NAFDAC in certain instances can trigger criminal prosecution against the infringer. This route may be appropriate for severe or widespread infringements cases with potential deterrent effects. We also then have the civil action, the most common enforcement mechanism involving a lawsuit with the Federal High Court seeking various remedies such as damages in terms of monetary compensation for financial losses incurred during the infringement. You can also have injunctions. We have a lot of cases in terms of injunctions where the court orders prohibiting the court orders prohibits the infringer from continuing with the infringing activity. And then we also have account of profits, requiring the infringer to disclose and surrender profits gained from the infringement. There is also what we call the delivery of, which is obtaining a court order compelling the infringer to hand over infringing materials to the IP owner. Specifically, so in some types of intellectual property type, like for copyright, we have what we call the antopillar order. This is very popular. So in exceptional cases, the court may grant such orders allowing authorized personnel accompanied by legal representatives and law enforcement to enter suspected infringers' premises to seize evidence of infringements like pirated material, production equipment. We can also have the criminal penalties. So the Copyright Act prescribes imprisonments or fines for various copyright infringement depending on the severity of that case. Now, if you are looking at trademarks on the other hand, we have the Cyber Crimes Act, which unauthorized online use of trademarks, such as through counterfeiting websites or misleading domain name, which is punishable under the Cyber Crimes Act, adding a strong deterrent to online infringement. There is also the anti-counterfeiting measures. The trademark owners can employ proactive measures like market surveys to identify counterfeiting hotspot and also conduct raids, market investigation at the trademark registry and police raid in collaboration with authorities to seize and destroy counterfeit goods. But of course, this is usually done in collaboration with government agencies. We also have the patent and industrial design. So for the patent and industrial design, the exploitative acts about patent and design can only amount to infringement when they are done for commercial or industrial purposes. Doing any acts for personal or family use or for a gift to another does not amount to infringement, but it's only when you are doing it to enhance commercial gain, that is when it's being considered as an infringement. And here, the onus of proof lies with the patentee or design owner to demonstrate that the infringing use was commercial or industrial purposes. And we also have the domain names. The domain name is like what we have here, like www.European Commission, the domain name of your products, the domain name of your services. The Uniform Domain Name Dispute Resolution Policy, UDRP, it's interesting to know that in Nigeria, we also have similar one, which is called NIRA, that's Nigeria Internet, and they are also responsible for the issues that deals with the infringement that is caused by the domain name. The rules for an efficient mechanism for the strict, cost-effective, and fair resolution of domain name conflicts by circumventing the traditional court system. Disputes are being adjudicated by specific bodies, and in Nigeria, we have the NDRP policy that defines the legal framework for settling dispute between domain name registrants and a third party. So when you have issues with someone using your domain name, it's interesting to know, apart from the UDRP, which is the national and international one, in Nigeria, we also have the local one. So for instance, if your brand is mobi.com.ng, so the .ng is the country code, which is for Nigeria. And it's interesting to know that we have NIRA here that examines or that is in charge of that. And if you have anyone complaints in terms of domain name infringement, you can always lay a petition to NIRA and they will treat it accordingly. To achieve resolution, the UDRP and the NDRP mandates administrative proceedings resembling arbitration proceedings in certain aspects. I've also discussed this. So we're going to be going into IP due diligence. What is IP due diligence? Recall that in this presentation today, we have discussed what are the benefits of IP strategies, having IP strategies. We've also discussed, we've examined the IP law landscape. We've examined the different procedures in terms of registrations and protection. We've also discussed today, we've examined what are the enforcement, what are the rights that you can have, what are the damages available to applicants, and how are all these things being done? And also, we've also talked about the AGR policy. We've also talked about the domain name. These are all the things that we've discussed so far. Now, we're going to be looking into IP due diligence. Imagine your company's knowledge, inventions, creative ideas as a treasure chest filled with gold, waiting to be unearthed. Identifying and understanding your intangible assets is the first step towards extracting their true potential and achieving success. Now, so what is IP due diligence? Why is it important? I'm sure you've been hearing IP due diligence. How does this work? How does it operate? IP due diligence is a detailed appraisal of your company's intellectual property. So basically, when you are doing an IP diligence, you are going into the patent, the trademarks, the copyrights, other intangible asset, trade secrets, providing a reliable assessment of their value and potential. When is it needed in Nigeria? So because we have scenarios of why is it necessary to have an IP due diligence? Why is it necessary to conduct the IP due diligence? So in Nigeria today, IP due diligence, having a thorough IP due diligence is very important in instances where you're buying, selling, or licensing IP assets before any deal accurately. Like valuing your IP is crucial for fair negotiation and informed decisions. 2, attracting investors. Or basically, if you are European SME listening to me this morning, why is IP due diligence important to you? In the situations where you want to come into Nigeria or you want to acquire a business, it's interesting to know the IP of the brand that you want to acquire. Why? Because it showcases the depth and strength of the IP portfolio of that organization, and also for you as well, investing to entice potential investors. Preparing for capital raise. So when you have an IP due diligence, you've conducted a thorough IP due diligence, it helps to demonstrate the value of your IP as the collateral for loans or other forms of financing. Institutions that deals with mergers and acquisitions and joint ventures, IP due diligence help you to ensure a clear understanding of each company's contributions when joining forces. Another interesting reasons why it's important to conduct an IP due diligence is for tax optimizations, which leverage accurate IP valuations for optimal tax planning and deductions. Now, when you're looking at this, we can have what we call the internal audit and external audits. When it's conducted by the company itself, and this is basically called an internal IP audit. So it helps to track your IP portfolio, identify the weaknesses, and what are the IP that you're using that is still important to you, that is generating more business for you, and the one that is no longer generating business, and you just feel that, oh, this is not necessary, so we do not need to spend money on annuity or renewal. That's what you do, what IP due diligence will help to do for internal audits. Now, for the external due diligence, typically it's performed by the IP specialist, and this provides an objective, third-party perspective that's often required by potential buyers or investors. Now, what are the benefits of IP due diligence? What are the benefits of IP due diligence? Number one benefit of conducting an IP due diligence is that it uncovers hidden gems. It identifies valuable IP assets you might not know you have. Because sometimes when we go into organizations, we conduct IP due diligence for companies, we realize that there's some IP asset that is within the company that the company has not even discovered or know that is in existence. But the IP due diligence would help to discover that. Number two is that it spots potential risk. Proactively, it addresses any legal or technical issues with your IP rights before they become a deal breaker. So if there is any risk that is happening, when you conduct an IP due diligence, this would help you to detect that. It also negotiates with, you are able to negotiate with confidence. Negotiate with confidence, so you have enough information when it comes to valuation, accurate valuations. You can confidently navigate IP negotiation and secure the best terms when it comes to using your IP as a means of negotiation or maybe like for collateral. It also increased management efficiency. So it streamlines your IP portfolio management for better protection and utilization. Now we are going to be discussing what is having an effective IP diligence process, ideally led by experienced IP specialists. What does it entail? How does it lead to success? So when you have an effective IP diligence process, ideally led by IP specialists, all your assets, like from patents to trademarks to copyrights, there will be like a complete inventory of every details of every IP asset in terms of trade secrets and all that within the company. Ownership rights. So it also helps to identify who owns the IP within the organization. IP due diligence is done most times to understand the ownership, especially when it has to do, maybe it's an employee that was the creator of that IP, or it was a third party, was the proper agreements done. Those are the things that the ownership and right is clearly identified. Who is the inventor? Who is the creator? Who is the statutory owner? All these things are always done via the IP due diligence strategy. Then in terms of the protection scope, it assesses the strength and validity of each IP rights. You know the strength of your trademarks, your copyrights, your patents, and your designs, and whether there is a need to actually go for renewal. So we have some brands in existence for over 100 years, and they're still in existence. It's as a result of the fact that they are making efficient use of the validity of each of those IP rights within the organization. Also, the market value. Determine the true market value of your IP in order to make informed decision. It's very, very crucial. And then we then have the final report, which is done. And then the culmination of due diligence process is a comprehensive report, a company's passport to making informed IP negotiation and strategic decision. So it becomes like a valuable tool for maximizing value of your intangible assets and propelling your company's success to the next level. So you know what your company is worth, you know the IP rights or IP assets, the intangible assets within your company, and you are able to take informed decisions for the business or for the growth of the business. I would also mention that going through the IP due diligence, it's important to note that we also have some challenges in IP practices in Nigeria. So I'll be discussing what are the main challenges of IP practices and what are the practical tips to overcome common issues. While Nigerian IP landscape has evolved significantly, we have new laws, we have bills in process, we have at intervals the different mechanisms also done by practice and also NGOs or bodies within the Nigerian system. Businesses may still encounter challenges that require expert guidance and directions, or even sometimes solutions. We have identified the following as some of the challenges of the Nigerian IP practice over the years as a practitioner here with over 12 years experience or 15 years experience now. I can categorically say that there is indeed some challenges within the system. So we have what we call the administrative bottlenecks. So the process of registering and enforcing an IP rights may face administrative delays in certain instances. We also have enforcement issues, which is enforcement can be challenging due to resource constraints and the complexity of pursuing the infringers. Remember that earlier on I've discussed the different ways to proceed with your enforcement, but there are certain instances where it's very difficult to get the resource that is required or complexity of pursuing the infringers. But however, I'm happy to say that when you are able to get your injunctions against them to stop them from continuing such acts, it will help as well. We also have awareness and education. There's limited awareness of IP rights among businesses and creators. And this can actually hinder the adoption of proper IP protection measures. And I think thanks to AFRIPI for this opportunity, because it has also created awareness for IP business owners for them to be able to know that their IP rights can go a long way in order to provide more revenue or enhance their businesses. Oh, then another main challenge is the archaic laws. If you recall, when we're looking at the different laws in Nigeria, we talked about 1965 trademarks and 1970 patent acts. Those are really, really obsolete laws. And in terms of trademark protection, the registry recognized the concept of claiming priority from a foreign registration. This principle has been formally incorporated into local laws. Consequently, the validity of trademark registration with foreign priority could potentially be challenged in courts. So, and that's why there is a need for us to domesticate some of these principles into our laws. However, this might prove advantageous for inventors seeking swift patent or design certificates. And then we also have technology adoption issues, personnel and training gaps in some instances, but it's interesting to know that WIPO and some other bodies, as well as practitioners in Nigeria, has helped a lot and Inter in order to help with the personnel and training gaps as well within the system. So what are the practical tips? One, collaboration with experienced local counsel. It's very important that if you are coming into the country to start your business and you want to use you want your IP to be the tool for you to maximize your potentials in terms of your business, you would need to have collaboration with an experienced local counsel. You also need to incorporate search culture in order to reduce refusal of your trademark applications and as well as your patent, to be able to know the equivalent searches for patent as well, and commence product IP registration well in advance of your product launch. Make sure that your IP is protected first before launching your products in Nigeria. This is one of the practical steps that can help you in order to overcome some of the challenges we face in practice. Now I'm going to be going into sustainable IP strategies for businesses operating in Nigeria. What strategies should organization, and if you're listening to me this morning, you are IP, you're a business owner or a service provider, and you're wondering, we've been talking about IP strategies. How do I maintain a sustainable IP strategy for business operating in Nigeria? The first thing to know is that an intellectual property strategy is a comprehensive plan that outlines how an organization will manage, protect, leverage their intangible assets. It's like a roadmap guiding decisions, actions related to patent, trademarks, designs, copyright, trade secrets, and other forms of IP. Some IP strategies for business success in Nigeria would include, for you to have a successful IP strategies, please take note, this is very important. One, you have to have a dedicated IP team. You can have an in-house team for larger organization, establishing a dedicated IP team, attorneys, analysts, expert fosters internal knowledge. And if you are a small, medium company listening this morning, it's interesting to know that you can also have external consultant. Smaller companies can actually tap into the expertise of external IP consultant to tailor strategies based on their specific needs and budget. When you are collaborating, or you have a dedicated team, or you have an external counsel that has the knowledge of IP or how this thing works, it will help your business. Two, prioritize brand protection. Work with external counsel, collaborate with legal professionals to analyze extant IP laws and regulations, because once you identify your IP, they will identify what category it falls into, and then we will identify which of the requirements is needed, how does the registration work, and then you get your IP protected. Another method is to conduct a thorough IP audit. Conducting a thorough IP audit would include inventory of your assets, identify all the forms of IP, the patent, trade secret, designs within the organization, access protection status, evaluate the strength of your IP rights, identify any gaps in protection, analyze competitor landscape. Competitor landscape simply means that you are benchmarking your IP portfolio against competitors to identify potential strengths and weaknesses. Seek professional guidance, engage qualified IP auditors or lawyers for a comprehensive and accurate assessment. This is very, very important. And then the final one is to value your IP assets. Go beyond IP audit, because the IP audit is to basically assess all the IP within the organization. When an audit identifies your IP, valuation estimates your monetary worth. Key consideration to analyze factors like the strength of your rights, the market demand, the competitive landscape, and financial performance. It's important to know that valuation results guide strategic decisions like licensing, franchising, collaborations, outright sale of your IP. All these things are very important to be able to have a robust or sustainable IP strategies for your business to operate in Nigeria. Now I'm going to be going into showcasing the business benefits of IP protection. So we'll basically look at some of the EU companies that have IP business strategies that has helped them and benefits of IP protections and the lessons learned from this organization or companies. EU companies such as Unilever, Nestle, Volkswagen, Siemens, Ericsson, and Ekins have been successfully operating in Nigeria over the past years. And one of the major strategies for their successful operation has been focused on intellectual property protection. If you look at most of all these companies, their IP protection is very key. While many have a global brand strategy, they adhere to some common IP strategies such as filing and protection of their IPR locally, word service, brand protection strategies such as opposition of similar marks, which is done as a result of word service, the market survey to determine counterfeit activities. So you see that at intervals, they engage their IP specialists, the local specialists, for them to be able to do these anti-counterfeiting activities. And that's why you see a lot of cases being instituted in court against infringers. Maintaining close collaboration with IP regulators for effective enforcement. These strategies have ensured that all these EU companies, they enjoy legal exclusivity, safeguarding the company's innovations and brands. And that's why you see the brand still being in existence even after 20, 30 years. Early detection of infringements, allowing timely prevention action. So when you notice this, you take action immediately. You do not allow it to slip through, because slipping through would then result in spending a lot of money for getting your IP right back. Brand distinctiveness and protection against dilution or confusion in the market, and counterfeit reduction. So I'm going to be looking at a case study today. And our case study is going to be Volkswagen Group. Volkswagen Group is a prominent German automobile manufacturer. I'm sure we all know what Volkswagen motor group is. So it's a German automobile manufacturer, which was established by the German government in 1937. It's a key player in the global automotive industry. And the company holds a substantial portfolio of intellectual property, boasting a total of 103 072 patents across the world, categorized into 51,579 unique patent families. Notably, 75,836 of these patents remain active till today, demonstrating Volkswagen's commitment to innovation. Beyond the global landscape, Volkswagen has strategically extended its intellectual property protection to Nigeria and other African countries. The company has secured trademarks in Nigeria under the umbrella of its parent company, enforcing its brand identity in the region. And then that's where you see them protecting even other Class 12 as well. In establishing a strong presence in Nigeria, Volkswagen has cultivated a successful business by partnering exclusively with a local distributor. The company has aligned itself with Stallion Group, serving as the sole distributor in Nigeria. The strategic partnership has not only facilitated Volkswagen's market penetration, but has also contributed to the establishment of a profitable venture in the region. This is a typical example of a company that has actually benefited from IP protection and is still benefiting from the IP protection up to today. We also have the Total Energies, which also has a comprehensive energy company headquartered in France, engaging in production and marketing of fuels, natural gas, and electricity, with a presence in Nigeria spanning several decades. The company places a significant emphasis on research and development, investing in the creation of innovative technologies and solutions. To safeguard their intellectual property, Total Energies has obtained patents for their innovations and secured national trademark protection for their brand identifiers. Globally, the company owns like a total of 14,278 patents, with 8,209 already granted. So they have already patent granted, they have 8,209, and over 45% of these patents are active, generating substantial revenue through licensing agreements till today. And these are one of the benefits that your IP can do to you. So apart from them protecting the patent, we can see that over 45% of these patents are still active, and they are generating substantial revenue from the IP assets. In Nigeria, Total Energies has registered multiple trademarks, strategic move to uphold the integrity of its brand in the market, mitigate counterfeiting risk, and optimize profit potential. So today, it's interesting to know that having a good IP strategy in Nigeria is a very good way for your business. It will help to push your business forward and also to make more revenue. And for you to come into the country, Nigeria, I have gone through all the IP laws. I have gone through the challenges that you might encounter, and I've also gone through what are the steps to take in terms of IP due diligence, and also look at the case study for you to come into the country, Nigeria, and for you to protect your intellectual property in order to have a profitable business. Thank you so much for listening. It's been a pleasure. Thank you very much.
Thank you very much, Tolu, for the comprehensive presentation. I think you can stop sharing, or technician can remove it.
Okay.
Thank you. I think that we have a couple of questions in the chat. I don't know if you can have a look at those and reply to our participants. The first one is, why is Nigeria not part of an international IP organization such as ARIPO? It's very broad. Maybe you can provide an answer in your opinion.
Okay, so thank you very much for that question. So ARIPO, yes, is the English-speaking African countries, but Nigeria is not a member of ARIPO, and I think that's basically maybe a political reasons, I don't know. But of course, Nigeria and South Africa are not members of ARIPO, and it's one of those things that we are still examining as of today. But it's something that has been in the pipeline. And even with the AFCA that is coming now, it's necessary that we realize that we have to be a member of an organization. But of course, there's still talks within the federal government. But as of today, Nigeria is not a member of any international organizations as ARIPO and OAPI. For that reason, like I stated, for political reasons, but it's not so expanded to the plugins. Some school of thought says that they wanted it to the headquarters to be in Nigeria. I don't know how far that is true, but that's one school of thought in that regard. For the second question, which says that I liked one major IP cases in Nigeria and how this was resolved. I think we've had a very good case, but so like we all know BHC, British Tobacco Company, I think they've also had a very recent cases in terms of the trademark infringement, and which also went all the way to Supreme Court, and where the Supreme Court says that ownership of a trademark is owned by the person. So we've had a lot of several cases like that. We've also had cases with FMCG companies as well, where they've also been able to, Procter & Gamble, which is no longer in Nigeria anyway. So they've also had major cases like that, which we've been able to go through their intellectual property and also institute infringement actions against counterfeiters in court. And they've been able to also obtain rulings in their favor as well.
Thank you. Thanks a lot, Tolu. Excuse me, I don't see any hands raised. Maybe I can ask a question. Do you know if when I want to apply for an IP right in Nigeria, and I am not a Nigerian national, do I need a representative to do so, or can I do it by myself? I'm thinking like a small company in Europe, for example, we can do that, but it really depends on national legislation. So I would like to know what is the case in Nigeria, if you can elaborate on this.
Okay, so for a foreign individual or company coming to Nigeria, you would have to have somebody like an IP accredited agent or law firm for them to be able to file your trademarks or your patent on your behalf. And then that's why, if you recall in my presentation, I stated that you will need a power of attorney, a letter of authorization for them to be able to act on your behalf. that is how it is worked in Nigeria. So you need to have a representative for them to be able to help you to file your trademarks or your patents or designs in Nigeria.
Okay, that's clear. So it works like in the European Union, meaning that if I am a national of the European Union, I can apply myself. But if I am not, I need like a lawyer who can represent me in front of the authorities. Okay, that's clear. And just another curiosity you mentioned also the alternative dispute resolution. I would like to know how does this work in practice? For example, if I want to use WIPO services or services provided by Nigerian authorities, is there like a procedure? Do I have to do it via a lawyer again? Is there a fee that has to be paid before being able to use those services? How does it work?
Okay, so for ADR system, so how it works now is that you make an application to WIPO. So for the ones that I've seen, from the one I've experienced, so you have to make an application to them, stating that the parties have agreed to have to go for an ADR process. So once you submit an application, you pay a fee, a reduced admission fee of $50. So that will be 50 USD per party. And then there's also the mediator's fee of $100 per party. And so this would also include like 4 hours of preparation and mediation, then additional fee of $50 per hour per party. And then you apply in light of the NCC WIPO collaboration. So what we have as of today in terms of the ADR for IP is the NCC WIPO collaboration, and they've provided their cost-effective resolution for disputes. And then they have the reduced administration fee of $50 per party, mediator's fee of $100 per party, including 4 hours. So usually, I would always advise that you go through your lawyer to be able to do this, because so that they can help you to prepare those applications. But it's also possible for companies to be able to do this where they have in-house counsel. But if you have a lawyer that's already representing you in Nigeria for your IP rights, it will be appropriate to go through that lawyer to help you apply for this, and then all these token fees are paid.
Okay, thank you. Thank you. Maybe we have time for the last 2 questions because we are over time already. One of those you can see already in the chat, Tolu, is that if there is any tool for searching IP rights that are already registered in Nigeria. I know there is a search tool for sure, but you can maybe elaborate on this.
Okay, yeah. So in Nigeria, in terms of searches, we have a search procedure in place, but it's manual searches that is being conducted. So there is no official platform where you can conduct your search as of today. So you have to make an application to the registry for you to conduct your search, and then they will be the one to conduct the search, looking at all the registers in place. And most times it's done manually. It's a manual process.
Okay, thank you.
Yeah. So the second one, I did not hear anything about timelines in terms of IP registration. Oh, kindly elaborate. Okay, so timelines in terms of IP registration, I thought I mentioned that. So for trademarks, it's usually between 18 to 24 months in terms of timelines for the protection of your IP rights. For trademarks, it's 18 to 24 months. For patents, it's between 9 to 12 months. It can be earlier. And then for design, it's 6 to 9 months.
Thank you. Thank you for the information. It's, of course, we don't have much time to elaborate more on this, but as mentioned in the chat, you have our email. If you have any specific query that you would like to ask or request for information, we can definitely take care of it at a later stage, and we will be happy to reply within the timeline we have set for this kind of queries. So I think that we can conclude our webinar for today. I would like to thank again Tolu very much for her presentation and for her expertise. And hopefully we will see her again in the future for covering other topics. Thank you everyone for your time today, and I wish you a very nice day.